For 125 years, the Chief Justice of Wisconsin Supreme Court has been the one justice with the most seniority. But that could change on Tuesday. Wisconsin voters will be asked to approve a constitutional amendment saying that the Chief Justice will be elected by the justices. And that's a very interesting issue, and it's a perfect topic for Wisconsinized civil dialogue. So I've asked Ann Jacobs, president of the Wisconsin Association for Justice, and Rick Esenberg, president of Wisconsin Institute for Law and Liberty, to have a civil dialogue on the issue. And before we get started, I want to thank Jacobs Law Firm for making their conference room available. Thank you so much.
Pleasure to have you here.
So thanks. Let's talk about the nature of the job, Chief Justice. Is it ceremonial, or is it, how much authority does it have? Before we get into the back and forth, because you have separate positions on the merits. So,
I certainly wouldn't call it ceremonial. I mean, the Chief Justice has only the single vote that they have, so the Chief Justice really can't control how cases come out in a way that the others cannot. But the Chief Justice has important administrative responsibilities, not only with respect to the court, but to the operation of the judicial system generally, and with respect to sort of the management of the day-to-day operation of the courts and the scheduling of oral arguments and the holding of conference and that type of thing. So it's an important job, but I think a very difficult one, because it requires you to manage and lead a group of very independent-minded people, all elected in their own right, yes, over whom you have no real power.
Any PS on that, Ann?
Well, I think that we shouldn't, it isn't ceremonial in the sense of it has a fancy hat or anything like that. Mm-hmm. But it has important parts in the administration of the court, and I agree with Rick on that. On the other hand, it also is a job that uses the collective memory of experience on the court to be effective and aware of how to administer really the entire court system from the top down. And that's part of what that role does.
And you're also the symbolic leader of a third branch of government in state government. So it's an important position. But as you said, Rick, you're only one of 7. Correct, right?
That's right.
Okay. But so let me play devil's advocate a little bit. If the court is doing its job, deciding which cases to hear, hearing those in oral arguments, rejecting some cases, holding administrative hearings, and issuing rulings in the cases it's accepted by the end of its term, what does it matter who's the Chief Justice if the judicial trains are leaving on time? And
let me give you an analogy. I think anyone who's ever been an employee understands that you can work for 2 different people and the job will still get done, and yet how it gets done can be vastly different. And one of the things that our current system does is it allows the justice with the most experience on the court to use that experience to create the framework within which those sort of administrative and logistic decisions get made. And it's that history and understanding that creates what I think is a well-functioning system for us and has been in place for the past 125 years.
Okay, now let's play the cards. What's the position of the Wisconsin Association for Justice?
We oppose that constitutional amendment for several reasons. One of which is really just sort of a philosophical one, that Wisconsin has had a long-standing history of electing its judges, and through that election, electing its chief judge. And if anything, I think we've seen in recent years the growth of more inclusion of voters in a lot of decision making. We've seen, whether it's recalls, whether it's school board referenda, we're really seeing more people participating in voting and in the process. And it seems to be going backwards to take that participation away from the voters. And that's what this constitutional amendment does. Right now, if you vote for the most senior justice on the court, you know that person will be the Chief Justice. And when Justice Abrahamson was running in, I believe it was 2006, it was well known, she's referred to as the chief, that you're running and that this woman is going to be the Chief Justice. And it seems to me an odd step backwards to take the ability to elect that important position away from the voters. Secondly, it also has the appearance of being a very political move rather than an actual administrative move. This appears to be very directly targeted against Chief Justice Abrahamson. It is certainly, the appearance is one where it's about her, and I think that's sort of the wrong reason to be changing our Constitution. And finally, there are good reasons why this manner of bringing our Chief Justice in is a good one for the state of Wisconsin. Again, seniority, understanding of the system, understanding of how our court system works comes with some experience on the court. And we should be encouraging that to continue rather than saying, well, if someone's elected tomorrow, they can come chief judge with no knowledge of how the administration runs. So I think it does a lot of things, this amendment does, that we really don't want to do. And that's why I think it's an unfortunate amendment and we're opposed to it.
So you're bringing the institutional knowledge argument. The Chief Justice Abrahamson was appointed to the court in 1976 by Democratic Governor Busey. She's been Chief Justice since 1996. So she has a knowledge of issues unique to the Wisconsin judicial system that goes back to 1976, correct?
That's one argument. I would frankly say that as a policy argument, I, as a voter, don't want to lose the ability to be a part of electing my Chief Justice.
Knowing that he or she is the Chief Justice.
Right. And I think that, if anything, we're collectively moving towards greater involvement, and this amendment takes us backwards, and I don't think that's the direction we want to go.
Rick, thanks for your patience. The position of the Institute?
Well, the Wisconsin Institute for Law and Liberty doesn't have a position on the amendment. I'm in favor of it.
You're in favor.
And let me tell you why. First of all, I think it is a misnomer to say that voters elect the Chief Justice as the Chief Justice. That is categorically not the case. There are states in which that is the case, where people specifically run for Chief Justice of the Supreme Court, but Wisconsin is not one of those states. Their systems look very different than ours. In our system, nobody, not a single voter in the state of Wisconsin, ever voted to make Shirley Abrahamson, for example, the Chief Justice, as opposed to one of her 6 colleagues. She runs as a justice. If I were a voter and I thought, you know, I really want to keep her on the court, I think she's a brilliant jurist, but I don't think that she has the skill set that's required to be Chief Justice, I have absolutely no ability to cast that vote to prefer one of her colleagues over her. If she were to retire, I would have no say, no vote on who would replace her. It would simply go to the person who's been there the longest. And that's somewhat of an anomaly in our system. We normally don't confer privileges and titles on people simply on the basis of longevity. Now, maybe it would be justified if we thought that this unique skill set, right? Remember, I told you it's a very difficult job. You know, herding cats is not an inapt analogy. You have to be able to manage people who you don't have authority over. You have to be subtly politic in a way that not everybody can be, including, you know, brilliant justices. You know, for example, and Ann will probably disagree with me on this, but I think that Antonin Scalia and Clarence Thomas are wonderful jurists. I don't think that they would be particularly good Chief Justices because I don't think they have that peculiar skill set. And it would simply be happenstance, sheer blind luck for the person who was most suited to be the Chief Justice, to have that particular skill set. It would be pure happenstance if that person just also happened to be the person that's been there the longest. But it seems to me there's a more fundamental problem. And that is that if you have to manage people, if you have to manage independent and lead independent lawyers who you don't have authority over, they've got to want to go along. And if you, for whatever reason, have lost their confidence, if they no longer want you to be their leader, you will not be able to lead them. And our current system provides no corrective for that circumstance. And so it seems to me that it's simply good government to allow this group of independent people, all of whom we did vote for, in order to elect who their leader will be. And I don't think that it's about Chief Justice Abrahamson. If I thought that, I think it would be a waste of time. She only has 4 years left on her current 10-year term. When that term expires in 2019, she will be 85 years old. People generally don't run for re-election at that age. I don't think that this is about her or any particular justice. This is about what's the best way to do it. And the fact that we are something of an outlier here, there are only 4 other states that do it our way. There are 22 that allow members of the court to elect their leader. I think it's a better way to do it. It's just good government. It's that simple.
Well, I want to address a few things. With regards to whether or not it's just about Justice Abrahamson, there were amendments brought in both the Assembly and in the Senate, yes, requesting that if this amendment go forward, that it say that it start in when Chief Justice Abrahamson was done with her term. Completely rejected. So there's a saying about, circumstantial evidence can be pretty strong. If it really weren't about her, there's no reason not to have had this amendment start when her term was over. Secondly, I think perhaps Rick didn't quite hear me. I said they elected her as a justice of the Supreme Court, knowing her to be the Chief Justice. That is a distinction, and I agree with him. We don't elect a chief. It doesn't say who are you choosing for chief, but when you vote, you have the authority to know, you have the ability to know that that person is the most senior person on the court and will become Chief Justice. The other thing, too, is that while 20 states do it one way, most of the states do it another way. And in fact, very few states are doing what this amendment proposes, which is having a popularity contest every 2 years as to the running of the court. Now, I don't know about you, but some jobs take a little longer to learn. And the idea that we're always going to be sort of restarting the boat with no longevity isn't also an ideal thing. And finally, I'm the president of one of the largest statewide organizations of lawyers. So I appreciate the idea of leadership and bringing diverse people together and leading them. That can be a challenge, but that's an argument about an individual, not about the job. And the job is what it is. It includes the requirement that people have this longevity so that they know what this job is about. And if you make it a popularity contest, then it's really not about what's best for the courts and what's best for all of us. And it also, again, doesn't allow us to have that input that we've had for over 100 years. I don't know why we would give up our voice in the court.
Wisconsin carries the administrative hearings by the Supreme Court. And at times, as someone who's a big fan of Wisconsin, it's tough to listen to, because here you have 7 of our best and brightest legal minds really bogging down. So here's my question. If there were a change in Chief Justice, would we see an improvement in the collegiality of the court? Your thoughts, Rick?
Everybody knows that we've got some problems with dissension on the court now, and it's very difficult for anybody who is outside of that to know precisely why it's occurring, just as it's difficult for somebody who's outside of a marriage, for example, to know why it's breaking down. But it does seem to me that for whatever reason, and I don't think we have to fix blame, that the current Chief Justice has lost the confidence of a majority of the court. Right? They would prefer to be led by somebody else. Now, maybe they're wrong in wanting that, but they do want it. And it seems to me that under those circumstances, if you want to have an efficient operation of a court, you have to allow the members of the court to choose their own leader. You simply, they cannot be made to go along, right? They have to want to go along. And, I think that the fact that to say that and to characterize this as a popularity contest, I think is, with due respect, I think is way too dismissive of the justices to think that they would treat it that way. I think we have to presume that the people that we've elected to serve on the state Supreme Court are going to take the task of choosing their leader seriously. And they're not going to take somebody who doesn't have the requisite institutional knowledge or who doesn't have the requisite political skills. They are going to pick the person that, in the context of this particular group of individuals, is best suited to be the leader. And I trust them to make that decision, particularly given the fact that, again, none of us in the state of Wisconsin have ever had an opportunity to vote for which one of those justices will become the chief. We simply don't do that in this state. We could do it, but we don't.
And your thought on whether collegiality would improve or get worse if there were a change in Chief Justice, ma'am?
If the premise is by electing who we want as the Chief Justice that suddenly we're going to turn a court that isn't getting along into a group of people singing Kumbaya, I don't think that's going to happen. I also think that the same logic about allowing people to elect themselves applies to people who have to work under an existing Chief Justice. This is the system we have. And it's like any other person who works in any other environment. If that's the person in charge, that's the person you have to deal with, and you need to be professional and you need to adjust to it. So I am concerned about the idea of creating a situation where every 2 years you've got people vying politically within a court to try to gain this position instead of focusing on the task at hand. And I don't see any reason to introduce that added sort of element of popularity, which Rick doesn't like, all right, the risk of horse trading or other sort of things that are going to come in to this biennial sort of process. The advantage of what we have right now is we know what it is, and we are all able to live with it. And again, we don't elect a chief, but we know when we elect someone if they are to be the chief. And that's the difference.
You've both done op-ed pieces that I want to quote from. And let's start with you. Your op-ed piece, which ran in a few newspapers around the state, says it's an attempt to, quote, change the referee, is the phrase that you used twice. Here's my question. If Justice Abramson and Justice Ann Walsh Bradley, who often see things the same way, they're in the minority, how is this changing the referee? Because a referee reverses a call, but if Justice Abramson and Ann Walsh Bradley can't get their way, how is it an attempt to change a referee?
The justices are not unified blocks, and I wouldn't presume to say that they are. There are times that the different factions on the court vote in different ways. And it's not that I think that there's these two justices huddled against the masses. What I think is going on, though, is the effective administration of the court, by virtue of doing it by seniority, takes it out of the political arena. It simply is. And if Chief Justice Abrahamson retires, it goes to the next person, and so on and so on. It isn't a political aspect. When you control administration of any organization, you have the ability to change how it runs, and what this is introducing a political aspect to that administration. And that's what I mean by changing the referee. We're changing how we administer this court to make it based on politics, and that's the last thing we need to introduce into this court is more politics. This is supposed to be straight up nonpartisan, and I recognize that there are folks who are trying to change that, but that's what it needs to be.
You know, I think that the proof of the pudding is in the eating. And if our system is supposed to render the court apolitical and sort of remove the dissension or the competition that would occur between the justices if they had to sort of select their own leader, I think we don't have to look any further than the record that we have with our court over the past 20 years to know that it's not working, because this court has been riven by dissension, and not always on ideological grounds. In 1999, we had an extraordinary phenomenon where 4 of the justices, sitting justices on our court, publicly supported Chief Justice Abrahamson's opponent, including Justice Babbage, who was an ideological ally of the Chief Justice. And it seemed to me that that had something to do, rightly or wrongly, with dissatisfaction with the way in which the court was being managed. And so I think we've got our own court as an example that, you know, that this really doesn't remove politics from the court. And then we have over 20 states in which members of the court elect their leader, and at least I'm not aware of any of those states in which we've had ensuing sort of dissension and chaos and competition that sort of compromised the ability of those courts to function.
And yet, I want to follow up on that.
Okay.
But the citizens of the state of Wisconsin returned Justice Abrahamson to the court. And that's what I'm saying is we can't give up our citizen right to have our voices be heard. So the justices said we don't want her. You know what? The citizens of Wisconsin said we do, and they've said it again. They said it with over 60% in 2006.
Well, it's just false. The voters of Wisconsin never elected, and they never said this is the person on the court that we want to be Chief Justice, because they are not asked to make that determination. It's almost like saying that if I live in John Boehner's congressional district in Florida, and I know that if I return him to Congress, he's going to remain Speaker of the House, that I'm somehow voting for him to be the Speaker of the House. No, I'm not. I'm voting for him to be a congressman. Whether he becomes Speaker of the House or whether the justice that I have voted for to remain on the court becomes the Chief Justice is a function of a rule over which I have absolutely no say.
The term you use in your op-ed piece is the current system merely anoints. That's a strong verb. The most senior justice is chief. So you want to talk about the verb anoints?
Well, because that's right. I mean, you get the job because you've been there the longest, and you keep the job as long as you remain there. Nobody has the opportunity to remove you. The fellow justices can't remove you. The voters can't remove you without removing you from the court altogether, which is an entirely different question.
It is.
And so it seems to me that anointing is exactly what happens, and that's why this is such an anomaly. You know, I remember that back in the day, I'm old enough to remember this, back in the day when Congress operated under a strict seniority system, right? The most senior member got to be the chair of all the important committees. And we came to realize, sort of along the lines of sort of promoting inclusiveness and accountability and responsiveness, that that's no way to run a railroad. And we moved away from that because we realized that while seniority and experience is important, and believe me, Steve, every year I've come to think that seniority and experience is more and more and more important, but it's not everything. And so, rather than simply let these important positions devolve to, rather than anoint the most senior person, we decided that it makes more sense to allow Congress to select its own leaders. And I think that the same rationale applies to this position as well.
Rick, and I want to come back to something Rick said. He said that he thinks that Chief Justice Abramson has lost the confidence, and correct me if I'm wrong, of the other, the four conservative justices. Do you agree? In terms of her ability to manage as Chief Justice.
See, but here's where it comes down to. The citizens of the state of Wisconsin elected her. They spoke. They had the opportunity to remove her, and they didn't. They want her there in that position. So the real question is, did the citizens of the state of Wisconsin lose confidence in her? The answer is no. And really, if the issue is that the other four justices, and I wouldn't presume to speak for them, and I haven't seen what their comments are on this, are at such a point where they can't respect the citizens of the state of Wisconsin's voice in this, I would submit that that's a rethinking that they would need to accomplish. When we as the voters speak, we have a powerful voice, and we should be embracing that voice rather than trying to take it away.
If the constitutional amendment passes, and I'm not seeing any polls, would you expect that the next Chief Justice would be Pat Roggensack? Because you and I have seen the speculation.
It's very difficult to handicap a race like that, which by its definition, but by its nature doesn't sort of happen publicly. But as somebody who's been an observer of the court, I would think that that's highly likely.
And what changes might a Chief Justice Roggensack bring, Rick, just to follow up?
Yeah, it's hard for me to say, and part of the reason why I think that it's a little bit it's misleading to say that someone has voted for someone as Chief Justice as opposed to simply being a justice, is that the type of things that the Chief Justice does are things that really sort of are off the radar screen, not only for almost all voters, but really for most lawyers. It may be that if the members of the court select their own Chief Justice, that the court will function in a way which is less likely to lead to the type of dissension and dysfunction we see. And I say that without casting aspersion or responsibility on anybody, because my guess is that it's far more complicated than a simple black and white, it's your fault or it's your fault type of thing. But I do think that when you have very independent people over whom you have no real choice, the consensus with respect to leadership is just inevitably important. There's just no way to get around it.
And any thoughts on what changes that a Chief Justice Roggensack would bring?
The fact that nobody can identify what these mythical changes are that's suddenly going to bring this court together is part and parcel of one of my concerns about this. What is it that's suddenly going to happen, other than, near as I can tell, some sort of hope that a group of people who supposedly don't get along real well will suddenly change how they get along by virtue of this? I don't think that's what's going to happen. And I certainly don't think that these aspirational, well, I hope that maybe something will happen, should be the basis on which we enact a constitutional amendment. We don't enact constitutional amendments on wishes and hopes and prayers. We do it with an idea of protecting our voting, protecting our democracy, and with a certain respect for the history that we've had. And I think that that's part of the issue in this.
And I'm not sure that it's true to say that nobody can identify changes, for example. But the thing of it is that they're the type of things that don't sort of register in the public imagination. For example, we've had a real problem on this court over the past number of terms, and the court comes out with its decisions very, very late. It's supposed to close its term like the United States Supreme Court on June 30th, and there have been terms in which the court actually had a median release date of its opinions in July. That is, over half of its decisions were released after it was supposed to be finished. There were some rule changes that were made. I think by the majority of the court, which changed the way in which opinions are circulated among the justices. That seemed, at least for a while, to speed up the work of the court. So I don't know that it's fair to say that nobody can identify things that would make a difference. But I don't, nor do I think that having consensus with respect to leadership is simply a hope and a prayer. It's something that in most areas of life we regard as important. If the chairman of the board has lost the confidence of the board of directors, the chairman of the board is typically replaced. That makes sense. That's good management. I think that the amendment makes sense in much the same way.
It's not spelled out in the constitutional amendment, but do you think if it passes and if there is a vote to elect the next Chief Justice, that vote should be made public? What do you think, Ann, in terms of how each justice voted?
That's an interesting question. I haven't thought about that.
It shows transparency, but you have a court now where justices can step off cases without saying why. So I just thought. Rick?
I'm inclined to think that it wouldn't be particularly important to make it public.
Any PS on that? Ann?
It is an interesting tension, isn't it? Do you want to list the people who don't win and the votes they received? Is that actually going to help the court? Does it simply cause unnecessary embarrassment, or is it transparency? I think it's an interesting question. It really is one that I haven't thought about. I can see from both sides on it. My inclination would probably be to say no, but I'd have to noodle on that for a while.
One of the issues that has been debated is the degree of openness in the administrative hearings. Should those continue to be open? Because there's been at times some pretty sharp conflicts between the 7 justices. Just your thoughts on that?
We need to stop making things more and more private. And we need to embrace our long-standing history in Wisconsin of open government, open records, and all of that, which may affect how I look at your earlier question. I'm still going to think on that.
Okay.
But we need to keep these things open. This is part of our right when we have our government functioning to be able to go and observe, to watch it on the internet, and to be a part of this process. And if they're all closed in, we lose that ability.
Well, as somebody who actually has sat and watched those administrative hearings back when they were on Wisconsin Eye at 4 o'clock in the morning,
they're still on Wisconsin Eye,
and it was me that was choosing to do it at 4 o'clock in the morning. I know that you're on demand.
24/7.
24/7. I have mixed feelings. Most states, I think, don't have those conferences in public, and there is something about a court as a deliberative body, which at least suggests an argument for keeping at least some of it out of the public eye in order to encourage candor. Because I think sometimes there's certain processes when you make them public, all you really do is shut people up, and that's not always a good thing.
Okay, we're almost out of time. I just have 2 more questions. My next question is, help me understand why WMC, it was reported today in the Wisconsin State Journal, is spending $600,000 to pass this amendment. Is that a good thing or a bad thing? And what potential reasons would the state's largest business group, its Chamber of Commerce, spend that money to try to pass it? Rick, your thoughts?
Well,
it's legal. I mean, it's
right. It's legal, and probably the question is best directed to WMC. My sense is that WMC recognizes the importance of the court in sort of fashioning or developing the law in a way which fashions policy in the state, and has an interest in seeing the court run efficiently. but that's my assessment of what's going on. They can probably explain their their perspective better than I can.
And your thought?
It's shocking, isn't it? More than $500,000 to create, to supposedly support this constitutional amendment that's nothing more than an administrative change. And again, it goes back to what I was saying before, that there's much more to this than just an efficient administrative change. It is obviously something that WMC has targeted as this change will advance our agenda. Now, why would a simple administrative change advance the agenda? So you sort of joshed with me a little bit about talking about changing the referee. That's a great way to make sure that your agenda gets forward. And it combines with the fact that this bill appears to have been targeted also specifically at Chief Justice Abrahamson. Why? None of the amendments that would have kept it from applying with her or to her passed through. So what do we have? We have an amendment that has the appearance of being targeted against a single justice that is trying to remove her from a position of some authority on the court. I think we can all be very concerned that that money is being spent on this. It's going to be interesting to see what it does, and it may have an impact on this. I don't think we'll know until it's over.
Do you have a very quick follow-up, Rick? I noticed your head shake.
Yeah, I mean, I think that's just innuendo. I mean, the Chief Justice is not a referee. The Chief Justice has no greater authority in deciding any cases that reflect the WMC interest. The only thing they could be interested in is the effect of the amendment on operation and administration of the court, because I think everybody agrees that that's all it affects. And maybe they think it's worth $500,000, which quite frankly in a statewide election is not very much money at all. That a properly functioning court is worth that. I certainly think it is.
Final question. Also being discussed on the Capitol is a proposed retirement age of 75 for the justices. Chief Justice Abrahamson is 81, Justice Crooks is 76, Justice Rogenzak is 74, Walsh Bradley is 64, Justice Prosser is 72, Justice Ziegler 51, Justice Gableman is 48. Good idea, bad idea to make justices retire?
The older I get, the less supportive I am of mandatory retirement ages. I don't know. I don't find it to be a particularly compelling issue for me, other than to note that if you take the Wisconsin Supreme Court and you take the United States Supreme Court, apparently being a justice on a law-developing court of last resort works wonders for your longevity.
Ann, do you have a thought on that?
It goes back to the voters. When they elect people, they know how old they are. And absent incapacity or other issues, I think these folks ought to be allowed to finish their terms.
Thank you. Let's close it this way. Closing remarks. You both are used to that. 30 seconds worth of closing remarks for your position. Rick, go first.
I don't think that the proposed amendment is anti-democratic in any sense. We don't vote for a justice as Chief Justice. We can't remove them as Chief Justice other than by kicking them off the court. If the Chief Justice retires, we can't select who the successor is going to be. That's no type of meaningful vote that I've ever heard of. I think that given the fact that the peculiar difficulties of the job and the fact that you simply can't lead a group of people like this unless they want to be led, I think that like 22 other states, Wisconsin ought to acknowledge that allowing the justices to elect their own leader, whoever that may happen to be, and you know what, it may be a conservative this time, but there are no permanent victories in politics. It may be a liberal the next time. I think that makes sense.
Closing.
We've been electing our most senior justices for 125 years. And the fact of the matter is, you know when you're electing your justice whether or not they're going to be the most senior person on the court or coming up the pike. And in this era of increased political involvement, we should never give up our right to vote. We should never give up our right to have our voices be heard. It's the only way we have of affecting our government. And the fact that we haven't heard a single example of precisely what this would do Not one, not a proposal, not a suggestion, not an administrative rule, nothing of what this proposal would do reveals it for what it is, which is ultimately a political attempt to manipulate this court. The WMC buy of $600,000 is testament to that, and we should be respecting our 125-year history of involvement in selecting our justices, by virtue of that selection, our Chief Justice, and we shouldn't give up those rights.
Ann Jacobs, Rick Esenberg, thank you for a very important civil dialogue on a very important issue. Thank you so much.
Yeah.
Thank you.
Thanks.